Hi, Jim Silbach. Today I'd like to take a couple of minutes to talk about an issue that comes up a lot in automatic stay violation litigation, and that is, what is a willful violation? And here's kind of the problem. The use of the word willful was probably not such a good idea, because willful to most lawyers has a different meaning than what it means under 362K, which is the willful violation provision of the bankruptcy code. So the common definition of willful is intentional, deliberate, conscious, malicious, purposeful, and done in bad faith. So if you ask most lawyers, what does willful mean? This is what they're going to tell you. But that is not the definition used in the willful violation statute. Under the circuit law in every state, including New York, willful simply means this. Number one, the creditor had notice of the bankruptcy, and the creditor took some act. So normally we look at the certificate of notice to make sure the creditor was properly listed, that the address is correct, check that box, had notice, and did they take an act? Now that could be an act. It could be sending a bill, making a phone call, serving a summons and complaint, income execution, all those things. But as we'll talk about in another video, it can also be the failure to act. In other words, let's say the creditor puts an income execution on the debtor before bankruptcy. That lawyer knows that that is in place. He gets notice of the bankruptcy, does nothing. He or she just does nothing. A violation motion is filed. The argument would be, I didn't do anything. The sheriff was taking the money out. That doesn't work. You have a duty to act when you know that there's been a bankruptcy filing. So it can be an act. It can be the failure to act. So that's what willful means under Section 362K.